Time is up in another high-profile legal battle in President Trump's attempt to remove illegal immigrants from the country. Today, a judge deciding whether Columbia University graduate student Mahmoud Khalil poses a national security threat to the nation and if he will be deported or set free. Khalil sits behind bars at an ICE detention center in Louisiana. The 30-year-old, a prominent Palestinian activist who led spring protests at Columbia University last year, was arrested March 8th in New York City. The agents acting on orders from the State Department to revoke his student visa. But after learning Khalil was a legal resident, they took his green card instead. 2 days later, a judge ordered the Trump administration not to deport him pending a review of his arrest. Ahead of today's decision, the Department of Homeland Security offering up this two-page memo. Secretary of State Marco Rubio cites the pro-Palestinian activist's beliefs as justifying his deportation. It doesn't, however, accuse Khalil of any crimes. Rubio writes his continuing presence in the U.S. would have, quote, potentially serious adverse foreign consequences and will compromise a compelling U.S. foreign policy interest. Lawyers for Khalil say the government hasn't provided any evidence to support that statement. I spoke with immigration attorney Herman Dade about the case.
Is there any evidence that this person has adverse foreign policy consequences or lied on an immigration form on whether he was, a member of UNRWA is what they're accusing them of? So is that even a material misrepresentation? Or is the government just stretching and just wanting to remove somebody who they, exercising his free speech in a way the government doesn't like?
In the weeks since Khalil's arrest, immigration officials have taken dozens of foreign students into custody and, in some cases, taken their visas away. Khalil's case now a crucial test for how far the administration can go to deport non-citizen protesters. Here now, Michael Wilds, managing partner at a leading immigration law firm of Wilds and Webner. He's also an immigration attorney for Melania Trump and the family. Welcome back. Thank you for being here. Are we still in limbo as to whether or not he has legal status in the U.S., or has that been clarified?
So he has a green card, and that's certainly been satisfied, and it's not, it's beyond reproach. The question ultimately is, will the immigration court see this as a measure of free speech and that the government does not have adequate proof of its support of terrorism? Or will the provision of law that allows the Secretary of State to declare somebody a risk to our foreign policy because of his conduct, not because of his free speech, make him removable despite having a green card? And this is a case of chilling effect to one side and a case of great national security on the other side. And that's really what's going to be portending itself later in today's court. I personally believe it's the fighting words doctrine. It's the conduct. A person who's stopping Jews from going to class is ripping off the stars and encouraging violent conduct. It's not the fact that he artfully believes in something as a measure of principle. This president, to his credit, would like to stop the threat of anti-Semitism. This Secretary of State, and I'm a very proud Democrat, you should know, is stepping up and putting effect to this anti-Semitism. And they're using a law on the books that offends many people because of the appearance that it's striking down speech, when in fact it's striking down poor conduct.
Okay, so on that I hear you. On the conduct argument, what evidence do you expect the government to put forth to back up their claims, as you put it, standing in the way of Jews getting to class, and how he was directly involved in that?
So first of all, the hostile takeovers of campuses, the threats and not telling people to stand down from any violent works, the ripping off of Magen David's or the Jewish Star, locking people in rooms, the whole notion of safety, security, and not restoring peace when you have a microphone. You're not allowed to scream fire in a movie theater. That is not free speech. That is a fighting word doctrine. It's a hallmark, if you would, that there is a limit on the freedom of speech when it comes to poor conduct. And I think ultimately the law stands, although it's a dated law and it has never really been invoked. the Secretary of State is arguing, and this immigration judge will have to make a decision. And it's, again, to one, speech, and to the other, conduct. Support of radical Islamism, the notion of this wokeism in controversy when it comes to a militant Hamas terrorist organization is really what the Secretary of State is fighting for. This PR for Hamas is not acceptable free speech.
Finally, Michael, if the judge does in fact rule against Khalil, is he deported immediately? What happens then?
Well, either side will file appeals with the Board of Immigration Appeals. From there, they also have the ability to file other federal court appeals if they wanted to, and it's a measure of principle. Again, the mayor of the city did nothing when it came to Columbia University. The governor stood by idly, and the president comes in and says it's unacceptable that this anti-Semitism and this conduct happened, and they're using a law on the books. Nobody's inventing anything. And if we want to make it look like we're taking away free speech, I understand and I respect that. This is right now in the hands of a judge.
All right. Attorney Michael Wilds, thank you for your perspective on this. Appreciate your time.
My pleasure.
All right.